Welcome to the Compliance 911 Show, a no-nonsense podcast discussing hot topics for today's busy compliance professional. It's everything you wanted to know about regulatory compliance, but we're afraid to ask. And now, here are your hosts, Dean Stockford of M&M Consulting and Len Suzio of Geodata Vision.
Hey Len, here we are today recording several different podcasts, but what interesting topic do you have for our audience in the next one?
Well, Dean, as you know, we are recording today only a few days after the momentous Supreme Court decision about the constitutional qualifications of the CFPB's funding. Now, I'm certain many bankers were hoping the court would rule the Bureau's funding as unconstitutional and say goodbye to all the regulations promulgated by the Bureau since its founding. But of course, the court upheld the constitutionality of the Bureau's funding. So the CFPB is still here to implement its regulations and pronounce many more. And we're going to talk about this, one of those issues today.
Yeah, and this is consistent. And I think, Len, if you go back and listen to some of our previous podcasts of what we were kind of alluding to, that we felt that this probably didn't have a lot of teeth. But so it's game over for bankers' hopes, I guess is the way to put it. But the Bureau's regulations will be struck down. And and again, I think if you go back and listen to our podcast, we were kind of warning people that we thought this may be the outcome, specifically as it relates to 1071, again, staying away from CRA.
Yes. Well, as one of the wisest and funniest men to ever have lived, Yogi Berra would say, "It ain't over till it's over." Yes. The Supreme Court did scotch banker hopes regarding the fate of the CFPB itself, but it didn't rule on other legal issues in many of the cases currently being litigated. Those issues, for which, by the way, stays have been issued on the funding issue, also include other specific legal questions that remain to be decided. For example, there are still unanswered questions about the small business rule in Section 1071 that continue to be litigated.
So there's still a possibility some of the CFPB's regulations will be struck down, Len?
Oh, yes. And there's some legal arguments about a number of the Bureau's regulations that have yet to finish the litigation process.
So what about Section 1071 litigation?
Well, regarding the Consumer Financial Protection Bureau's, the CFPB's, new small business lending rule and the data collection associated with it, and the reporting, of course, associated with the rule, in October of last year, that's 2023, a Texas federal court entered a nationwide injunction covering all small business lenders, essentially saying that both the implementation and enforcement of the 1071 rule would be stayed pending the outcome of the Supreme Court's decision in Community Financial Services Association case, which is the case that was decided a week ago as we're recording today. And if the CFPB prevailed, the injunction would be extended for a period of time equivalent to the number of days the injunction was in effect prior to the Supreme Court decision. So what does this all mean? It means that the injunction about 1071 and the small business rule remains in effect, but only until July 18th, 2025 for what are called Tier 1 banks when the data collection begins, and until June 1st, 2026 for initial reporting for the Tier 1 banks. For Tier 2 lenders, I shouldn't say banks because it does include non-banks as well. For Tier 2 lenders, the compliance date has been extended from April 1st of 2026 to January 16th of 2026, with the initial filing required by June 1st of 2027. And for Tier 3 lenders, those are the ones that are under 500 covered transactions, we're talking about compliance date is extended from January 1st, 2026 to October 18th, 2026, and initial reporting will be required by June 1st of 2027.
I'm just going to stop you real quick, Len, because
Sure.
there's something I got a little confused on here. And that
Sure.
when you mentioned the Tier 2, you mentioned that the date would be extended from April 1st of 26
Oh,
to
yeah, you're
January
right.
16th
Yeah.
of 26. I'm
Yeah.
wondering if is that 27?
Yeah, I believe so. It's supposed to be extended 290. What was it? 291 days.
Oh, yeah, that would make sense, yeah,
Yeah,
so
yeah,
it'd have to be the 20, yeah, okay,
yeah,
because
yep, yep,
their filing required would be June 1st of '27, so, yeah, it'd
yep.
be January 16th of 2027.
Right.
Okay, good.
So,
Sorry.
I'm glad you caught that. There's a lot of room for confusion, believe me. And by the way,
Mm,
this all points out what I think is one of the silliest aspects of the small business lending rule are these odd dates for data collection to commence, not only in the middle of a year, but in the middle of months in the middle of the year. So this means that the data collected in the first few years will be worthless for CRA and fair lending purposes because it's not going to be whole year's worth of data. And it's particularly obvious that many of the tier one and tier two institutions will be required to collect and report data under both the current CRA and Section 1071, at least during the first year of their reporting, since the 1071 data will be incomplete and worthless for compliance purposes. I personally think that the Bureau has decided to do that because they want to practice on how they're going to process the data that's going to be submitted by the lenders, but unfortunately, that means a number of lenders are going to have to collect and report data under both the new Section 1071 rule and the current CRA rule, at least for a year or two. So it's going to really increase the compliance burden for those tier one and tier two institutions. Um, and I also wanted to make certain, by the way, that the audience understands as we speak here today, there's no injunction pertaining to the current ongoing litigation regarding Section 1071, which is based on some of the features of the regulation apart from the CFP's funding, which was just settled by the Supreme Court. So the clock is ticking, and the effective dates for the different institutions' tier levels are proceeding ahead.
so can you recap what Section 1071 issues are that continue to be litigated?
Yes, well, actually, more than one lawsuit, by the way. There's the major one that was brought by the Texas Bankers Association lawsuit. And what they're litigating are the following. Number one, that they're saying that the Bureau exceeded its statutory authority by imposing additional data points beyond the 13 points that were specified in the actual legislation itself. But in Section 1071E, subsection 2H, Congress did allow the Bureau to require additional data that the Bureau determines would aid in the fulfilling of the purpose of Section 1071. However, in reading this language to provide authority to the Bureau to require the rules expanded data points, the CFPB disregards the text of 1071, which allows the CFPB to require lenders to disclose only information already obtained by the lender from the application process. So that's along with the 13 mandated data points. Now, the second thing is they're alleging that the Bureau acted arbitrarily and capriciously in violation of the Administrative Procedures Act and ignored warnings about the exponential cost increases, which will cause many lenders to leave the market and thereby injure small business. So that's the second issue that they're raising. A third is it's also alleged that the Bureau may fail to justify the cost in comparison to any of the supposed benefits in the new rule. And then finally, these other two lawsuits, there's one that's in Kentucky and one that came from Florida, allege also violations of the Administrative Procedures Act. And in addition, violations of the First Amendment regarding the rule's prohibition on discouraging applicants responding to requests for data. So the Florida lawsuit involves sales based financing, and the regulation violates the ECOA because sales based financing does not constitute credit under ECOA and Reg B. In addition, by the way, the politics of 1071 are very interesting. Congress did try to rescind the regulation, and in fact, there was a bipartisan vote in both the House and the Senate to invalidate the new rule, but the vote was vetoed by President Biden. So, notwithstanding the bipartisan opposition, Section 1071 and its small business lending section are proceeding toward implementation.
So, what advice would you have for our listeners regarding 1071, Len? Should they start? Should they not?
Yeah, start, stop, start, stop. Well,
Yeah, exactly.
I would recommend that small business lenders, and I'm talking not just about banks, but I'm talking about credit unions and lenders who will be covered by the rule, start developing data collection and reporting procedures and contact their software providers for plans and updates on software development. Now, also, the regulation does allow the collection of mandated data to commence a year before the effective data collection date so that institutions can test their systems and procedures. This is what some people have called the free look period, and it allows lenders to collect data required by the small business lending rule that ordinarily would be illegal to collect, commencing a year before the mandated start date for collecting the data. Some lenders may want to take this opportunity to test and fine hone their data collection procedures.
This has been a very interesting topic and conversation, to say the least. We're getting a lot of calls already about 1071, and of course, everybody's saying, "What do we do? What do we do?"
Mhm.
So we told them it was coming, but again, great topic, and thank you, Len, for enlightening our audience today. This is Dean Stockford with M&M Consulting.
And this is Len Suzio of GeoData Vision saying thank you for listening in today. And again, let us know of any subjects you would like us to address in future podcasts.
Thanks for listening to the Compliance 911 Show. If you like the podcast, be sure to subscribe so you don't miss an episode. While you're at it, please give us a like and review to help others find the show. As always, links are in the show notes, and you can always find us online at compliance911show.com. Follow M&M Consulting and GeoData Vision on LinkedIn for all the latest news and information on compliance hot topics.